Law Chat New York with your host Philip Scatone, attorney at law, and co-host Patrick Garcia, attorney at law. And now, Law Chat New York.
Hello, and welcome to Law Chat New York, a program dedicated to explaining our legal system, legal issues that affect our lives. My name is Philip Scatone. This is my co-host, Patrick Garcia. We have both been practicing law over 25 years. Mr. Garcia is a retired support magistrate. Good evening, Patrick.
Good evening, Phil.
Our topic tonight, bankruptcy. Almost 1 million people each year file for bankruptcy in the United States. It is a major decision for a person who needs relief under Chapter 7, 11, and 13 due to having debts they cannot repay. Is that correct, Patrick?
I believe so, and it's unfortunate that we have it with a bad economy, but we do have it.
I'd like to introduce our guests. Arlene F. McRae is a family and matrimonial attorney, graduate of CUNY Law School. She practices in New York and works in a program giving advice to constituents of the City Council. Now we have, to my extreme right, Jacob Silver, graduate of Brooklyn College with a BS in accounting, graduate of Brooklyn Law School. And Jacob has been a bankruptcy attorney since 1994, admitted to practice in the federal and appellate courts. Good evening and welcome to Law Chat.
Guys. Thanks.
Good evening.
I'm going to start with Jacob. Jacob, what is bankruptcy?
Well, bankruptcy is basically a court proceeding where the person filing bankruptcy, also called the debtor, is looking to get rid of some or all of their debts. In a bankruptcy, the debtor typically files a petition under chapters, generally for an individual, it would be under Chapter 7 or Chapter 13. They would go to court, and with the court's approval, through a process, they'd be able to get rid of many types of debt.
The Chapter 13 has, people get confused. I think sometimes people have heard of 11. I don't know if they've heard of Chapter 7 and 13. 13 is for reorganizing. You don't actually lose assets or...
A Chapter 11 is for businesses.
Right.
And well, I guess what we would be dealing with now more is a Chapter 7 and a Chapter 13. In a Chapter 7 called straight bankruptcy, often as what most people refer to it as, you're basically getting rid of your debts. You're not going to have to make any payments to creditors. And you're just looking to get rid of what are generally credit card debts, loans, debts of that type. Chapter 13 is a little bit more of a trade-off. It's more of it's a reorganization. You enter into a repayment plan up to perhaps 5 years where you make some payment per month. And in exchange for that, you get certain other benefits, such as if you have a mortgage that you've defaulted on, you can repair that default. Instead of, if you've fallen behind your mortgage, let's say 6 months, and the bank says, we don't want your payments anymore, we want your house. You can say, bank, no, I'm filing for Chapter 13, you can't take my house, and those 6 months of payments, I'm going to pay that back over a period of 5 years.
In other words, bankruptcy is, you might say, a gift of the government to those who get over their head in debt and don't know what to do.
Exactly.
Arlene, you're a family lawyer. You deal with child support, alimony, things like that. Is a domestic debt owed to a family, is that dischargeable in bankruptcy?
Well, I would be specific with respect to, let's say, child support. Child support is not, you can't get out of paying child support. I mean, people would love to get out of paying child support, but you can't, get out of paying child support.
You can't cheat your family by running up unpaid arrearages on child support and then go to a bankruptcy court and get it discharged, and you get away without not paying to your family.
Absolutely not.
Now,
you still have an obligation to take care of your children.
Yes, that's correct.
Now, in other words, this is a federal case.
Yes.
And we need to have, I guess, an attorney to do this.
Yes.
I mean, I've heard of pro se or people trying to do their own petitions, but it's an extremely difficult petition, isn't it?
It's extremely difficult. First of all, it is about 50 pages. And I can tell you that if you're not an attorney, and if you're not an attorney who is in fact doing this on a regular basis
Right.
or a daily basis,
This is a
as I do,
specialty.
it's really a specialty. And I have seen pro se people, and it is interesting to watch. You go to court, they stumble through it, they haven't listed all their assets. The trustee who we'll talk about who reviews these cases gets frustrated. There's a lot of yelling.
They didn't
Usually-
send out citations.
they didn't do a lot of the things that they were supposed to. And then what happens is they have to go to court instead of one time, perhaps 2 or 3 times. There's a lot of aggravation. They may not get the bankruptcy discharge, which is what they want, the discharge of their debts. And that's
Patrick,
unfortunate.
Patrick, you have clients sometimes, tell you they're broke or they don't have any money. Maybe the discussion comes up when your fee comes up.
Well,
But
they used to be clients.
do you tell a client your first resort is bankruptcy, or do you tell them that there are other things they could do to counsel their credit or to try to avoid bankruptcy?
Well, my first thing would be to tell them to go see Jacob. I wouldn't intend to do that. I mean, that's why there are people like Jacob that you send them off the street to go talk to him about what to do about your debts.
Jacob, what is exempt property?
Now-
I mean, if I go bankrupt, does that mean I lose everything I own?
That's the question bankruptcy attorneys always get on the phone, even before the client comes in. Can I keep my car? Am I going to lose my house? And the answer invariably is no. You're generally not going to lose these assets. And it's complicated, but basically there are 2 sets of exemptions
Right.
that you can choose from.
One from the state and one from the federal?
Right.
Is that
The
it?
federal exemption applies to most states. It's basically the federal government said, here's our standard exemptions. We recommend you use them. And states have a choice of choosing either to allow debtors to use those exemptions, or they can make their own exemptions. New York has been very generous. New York not only will let you choose to use the federal exemption, you have a choice of using the New York State exemptions instead of the federal exemptions. Now, why would you choose one or the other? Well, each set of exemptions has its own benefits. And I can give you an example. For instance, if you own a home, if you're a married couple and you both file bankruptcy, you're allowed to have $300,000 in equity. I mean, so if you own a home that's worth $800,000 and you have a $500,000 mortgage on the property, it's no problem. You could wipe out your credit card debts, keep your home, you get through the process unscathed, and it's a benefit to you. Your car, you can have $4,000 in equity in a car, which means you take the value. If the car is worth $12,000 and there's a loan on the car for $8,000, you can keep that car. That's not a problem.
Jacob, sorry, I have a question for him.
Sure.
A lot of people, inquire and even ask me, and I'm like, I don't have the answer. I don't do bankruptcy, but they ask a lot about school loans. I mean, if you file for bankruptcy, can you include your school loans that you've taken out for college, for graduate school? Are they?
That's a good question. I get that question whether in terms of public loans, or sometimes debtors think that there may be a difference because they have a private loan. The law as it is now, and bankruptcy law is changing. You really have to read all the new cases coming out. But the cases so far talk about the way they interpret, the standard is undue hardship. Now, when you start telling a debtor, the standard is undue hardship, they go, that's hard for me. I can't pay back those student loans. But unfortunately, that's not the standard. Undue hardship means your inability to pay them back now and in the future. So you're talking about someone who may have a disability, somebody who can't work, physically disabled might be the case. I mean, there are always exceptions, and it always makes sense to speak to an attorney when you're contemplating bankruptcy or have this issue.
Is there ever a situation where the bankruptcy judge might look at your situation and say, we just think you were just totally careless, so why should we bother helping you?
Well, that's a good point. There are certain standards in the bankruptcy code to prevent certain debtors who are, if they're abusing the system, from getting the bankruptcy discharge. And that's something I think that pro se people aren't necessarily aware of when filing their cases.
I want to back up and talk about that there are different types of debt. I think you mentioned mortgage. Some debt is secured by something and some debt is unsecured. What is that?
Yes.
Just
And
walk me
what
through
that would mean is, for instance, if you own a car,
Right.
and there's let's say it's worth $12,000, you have an $8,000 loan on it, that loan is secured.
Right.
So
By the car.
by the car. So it's secured on the car. If you look at the title, it's going to have your lender on the title. They have a lien on that car. So if you file bankruptcy, you can choose to either keep the car. You could keep the car and keep making the payments, or you could say, you know what, that car's a piece of junk. It keeps breaking down on me. I don't want to make those payments anymore. So I'm going to file bankruptcy. I'm going to just push the car back to the lender, and then the debtor won't have to make the payments on the car.
Right.
And you can keep your other assets.
You know, there's something very, very important. You know, hopefully the present companies never had to go through that, but when you owe money, people are calling you, they're sending you letters, they are sometimes almost threatening, and when you file for bankruptcy, Arlene, is there a stay or is there some kind of relief from people dunning you and sending letters and harassing you to get paid back?
Right. From what I understand, yes. You know, as long as they will find out that you're in bankruptcy, so that all the calls can stop, all the harassing letters can stop, and that's some type of relief for people going through the financial hardship. at the same
Jacob,
time.
you have to notify your creditors that you're doing this. So how's
Yes.
that work?
Well, let me just tell you, just to add to that. I mean, when I speak about bankruptcy, people think it's like a sad thing, and it is sad to the extent you meet people who have just been so beaten down. Sometimes they suffer from medical illnesses. They can't work. I remember one woman, a single mother, coming in telling me one day she was cooking for her daughter, and the collection agency kept calling and calling, and then one day even her daughter picked up the phone, and they said, "Put your deadbeat mother on the phone. We want her to pay back her debts," and she was upset. And we filed a bankruptcy for her. We got rid of that debt. We got rid of all her debts. And the beauty of it is, at the end of the process, you see a different person. You see someone who, before this, couldn't focus on working, couldn't focus on their family. You know, they're running like a hunted animal. And now you've cleared that away. They can focus on their work. They can be productive. You bring them back.
So that the debt that was discharged and they're never going to get sued for, and it's never going to come back up in any way. It's just gone.
Right. So in the process, as you mentioned, the automatic stay, the first thing you do is you meet with your attorney. There's a consultation. And I think while clients think that they're interviewing me, the reality is I'm interviewing them. And not only do I want to hear what they say, I want to see what the nonverbal cues, what they're telling me. I want to hear their story. You know, what caused them to file bankruptcy? Were they sick? Did they lose their job? Did they have a child who was ill? You can miss a lot of work because of that. It's not always easy to take off from work. And you go through it and you prepare a strategy for them. What chapter they're going to file, what debts they can get rid of. And when you're done with that, and you get all the documentation together, and there is a lot of documentation you have to put together, you file the case. Today, everything's electronic. We used to run to the court with the papers. They would stamp it. No, that doesn't exist anymore. You can file it like at midnight. You hit the upload button. It goes to the bankruptcy court. Now, but when you hit that upload button, the automatic stay goes into effect. And what the automatic stay does is it stops all collection activity. And that's really what the clients are looking for. They're being hounded. They're being hunted. And what it does is, at that point on, collection agencies can't send them letters, can't call them on the phone. And you know, they call them at work, at home. That has to stop. Right. They can't sue them. If they've sued them, that's got to stop. The debtor can breathe.
And you have to be totally honest with the bankruptcy court. If you're hiding assets or you are in any way trying to make a fraud by having run up a debt immediately prior to filing bankruptcy, there is statutes in place that you can't get away with that.
And that's absolutely true. There really is a lot of oversight. The oversight is provided by the United States Trustee's Office. They review these cases. I mean, if someone does lie, they could prosecute them for fraud. But the key word is, and the key word really is disclosure. Right. That's really what bankruptcy is about. You have to disclose everything in your petition. And the petition is, I have one here, it's about 50 pages. It goes in depth about your financial
50
situation.
50 pages, two-sided, too.
It's a lot. And it's all of your assets, your liabilities. And in fact, they ask you questions under oath about it. You have to testify.
There's a hearing.
There's a hearing. It's called the 341 hearing, named after Section 341 of the Code. And the question I get from debtors often is, you know, do my creditors show up? Are they there? And the answer is that there is a representative from the United States Trustee's Office. They come there and they evaluate each petition. They review the petition. They ask you questions. Your creditors generally do not show up at a meeting of creditors. In terms of Amex, Citibank, Sears, generally they're not there. If you owe money to your brother, he's there. And he knows everything about you. Or an ex-wife.
Right.
She's there. And she knows where, if there are assets that are hidden, she'll know, and she'll tell the court there. So especially it's important to realize that disclosure is the most important part of this case, and putting everything on the table
And being honest.
and being
Do,
honest.
do you, as the bankruptcy lawyer, have to in some way verify or certify that there's a certain amount of work you've done to ensure the veracity of that petition?
And that's correct. There have been many changes to the bankruptcy law. Some of them since 2005
That's
did make the attorney
The Bankruptcy
verify.
Abuse Prevention and Consumer Protection Act.
Right, and that just made it much more. What it did was it added to the bankruptcy petition. Instead of being about 25 pages, it became about 50 pages. It took about twice
But
as
there's a
long
reason
to
for that. There's a reason
to
for
fill out. It's named to prevent abuse.
Right.
But the reality is, it was the credit card companies lobbied Congress, and they made it much more difficult to prepare the petition. In other words, I don't see anyone who would have qualified before who now doesn't qualify for
Right,
bankruptcy.
right.
But now you have to fill out, for instance, this means test, which measures your income to see whether you qualify for bankruptcy. And it's a test where you have to compare your income to 60 different IRS averages of expenses. You need it's impossible to do without a computer.
Is there a certain amount of money or debt that you can put into bankruptcy? Like, is there a cap on?
Yeah, that's a good question. In Chapter 13 there is a cap, but in a Chapter 7 case where you're looking to get rid of your debts, there's no limit in the amount of debt that you can discharge, and there's actually no minimum debt that you need to list to file bankruptcy. I mean, to some people, $100,000 is a lot of debt. To some people, $20,000 is a lot of debt. To some people, $5,000 is a lot of debt, and they're happy to file bankruptcy to be able to get rid of that. Because remember, it's not just the debt, it's the interest. Right. And at the interest rates, if the credit card company said, we'll charge you 5% interest, a lot of people would say, I'll try to work it out, I'll make payments, I'll pay it back. But at the 30% interest rate, you can make payments all you want. You're never going to get that balance down.
Right.
And I think it's just very important just to add, before you go into the bank, before you think of trying to pay back your creditors or working things out, it's always good to have a consultation with a bankruptcy attorney. Because a lot of times creditors will talk you into, well, just pay us off. You pay us off, or you think taxes. Oh, I owe taxes to the government. I have to pay that off. That's not dischargeable. That's not true. Certain taxes are dischargeable in bankruptcy. So it's a good idea before you do anything, just get a consultation, learn what your options are, and then you could decide to do. Bankruptcy isn't right for everyone, but for a lot of people, it's a good way to get rid of your debts.
Jacob, can you file for bankruptcy every year? Let's say, you want to run up debts and then go bankrupt again and again and again. Can you do that?
No. I mean, basically, and for a Chapter 7, which is a gift, it's once every 8 years from filing. So when you file a case, you can't file another Chapter 7 for another 8 years.
So, I've heard this. I don't know if it's true. It doesn't really, this area is difficult for me. But in other words, your credit could actually go up because you file.
You would expect your credit to go up
Because
you file.
anyone lending you money then knows you can't declare bankruptcy again for 8 years.
Well, there are a number of things that happen after bankruptcy. The first thing that happens is people think that they can't get credit, it'll never happen. And I've had clients come to me and say, 2 months after the bankruptcy, I got all these credit card offers, and I was back in credit cards. I got them all again.
I was back in debt.
And I actually encourage people to have at least one credit card, because first of all, you need it to get gas for your car, but it's also important, it helps you rebuild your credit. You charge a little bit irresponsibly, and you pay it back, and that helps your credit. But what's happening after the bankruptcy is you're getting all of this debt off your Social Security number. So in other words, now when creditors look at you, they go, oh, look, this person is debt-free. How many people in America can say that? And not only that, this person can't file for bankruptcy for another 8 years. So we know we're lending to someone who's a better risk than a random person in the street.
Obviously, anybody watching this, say bankruptcy, I've heard of that. It's, hope it's a bad thing. But I think the first thing is, to try to, if you feel you're getting over your head, get some help.
Yes.
Check it out and make sure that you're living within your means. and that you're not running up numerous credit card debts, which could be consolidated or can somehow be lowered. And you also, as you said, even a tax liability could be negotiated down under certain circumstances. If you're in good faith, you didn't
could
lie,
actually-
you're not
even
hiding assets.
In bankruptcy, you can actually discharge it. Depends.
Right.
It depends if it's old enough. It's a very complicated area of the law. But basically, you would start off with it being at least 3 years old.
Now, when they
And you
finally,
filed your returns, you were honest.
when the bankruptcy court finally makes the estate of how much is left over after taking away the exempt property, they then have to pay out to creditors. And who gets paid for? Is there like a hierarchy, like certain people get paid first? Many people have asked me, does the government get paid first? I said, I don't know. Go to Jacob.
And that's a good question. Now, in a Chapter 7, the first thing to know is creditors almost never get money. They almost never get anything. I mean, creditors only get money if the debtor has an asset that they can't keep in bankruptcy. So what a bankruptcy attorney is doing is we're reviewing the case and we're looking at their assets. You have a house, do you have more than $300,000 of equity? You have a car, do you have more than about $4,000 in equity? And what happened over the last few years is New York actually, with these new exemptions, you can have this $12,000 wild card under the federal exemptions. So it's either a choice. If you're not taking the homestead exemption of $300,000, you have this $12,000 wild card. So you can actually have $12,000 in the bank, file bankruptcy. You could have $100,000 in your 401k, no problem. Cash value life insurance, another $50,000 or more. You can get rid of your debts and you can actually keep that. So what's happening now is you're finding that the cases, they're all no asset cases.
And bankruptcy are dropping. They're not as much as they were in some years ago.
There are fewer cases. It has been picking up lately, I will tell you. I mean, the biggest years, you had after 2007, the recession, it follows the recession inversely. When the economy goes down, bankruptcies go up.
Have you ever turned away a client and said, you don't really need this?
Yes. Well, there are some times, and I recommend this to someone, even if they're thinking about bankruptcy, call your creditors. And I think it's unusual. People are afraid to call their creditors if they get in trouble. But call your credit card company and say, look, I'm in trouble. I lost my job. I need some help. Can we perhaps allow me not to make payments for a few months? Can you reduce the interest rate? And call them frequently. You can call them. It's not just them calling you to harass you. You can call them if you have a program. And a lot of times if you call them enough, they'll say, look, we'll reduce your interest rate, and maybe you don't have to file bankruptcy. But often the case is, if you've lost your job, you've been out of work for a year or so, you may be so heavily in debt trying to support your family, trying to feed your children, that bankruptcy is the only option.
Well, I mean, there was once a time when they put people in jails. I mean, if you read your Dickens and novelists like that, they used to put you in jail because you owed money. And it still happens in certain situations, like, isn't that right, Arlene?
Yes.
Child support, willful child support,
Right.
failure to pay.
Right.
So,
And that's a good point. What I tell clients is, you have a problem here. It's not a criminal problem. It's not a health problem. It's a financial problem. Even if you don't do anything, even if you don't feel bankrupt, if you don't file bankruptcy and you just tell your creditors, I'm not paying you, they can't throw you in jail. There's not that much they can do to you, but what they can do is, and it is important to talk about it, they can garnish your salary. They can take 10% of your salary, your gross salary. If you have money in the bank,
one
they
thing,
can freeze that account.
Arlene, there's a special garnishment for family debts, which is going to be more than a creditor, a normal, the normal, like you said, credit card company or a bank is going to be able to levy.
Yes.
And as a family lawyer, supporting a family is very, very seriously important. And that's one of the places they can put you in jail, take away your license.
Right. Well, yeah. I mean, obviously, as we said earlier, you can't discharge your child support obligation. Obviously, if you don't pay that, then you can, go to jail if you don't address the issue. If you have financial problems, then you have to, go to court and address it. So.
And I find it's interrelated often. You see people coming in, they have a large child support payment they have to make, and now they can't pay their credit cards. So what bankruptcy would do is it would allow you to get rid of all your credit card debt, your loans, and then at that point you're in a position where you can catch up on your child support, make those payments, and that becomes manageable. Because if your creditor on the credit card is garnishing your salary and freezing your bank account, you won't be able to make those child support payments that easily.
Well, but I think the child support gets paid first, doesn't it?
It does out of your check, yes, it does.
We have some questions from our clients, which they've asked us to ask. Are people who file for bankruptcy financially irresponsible? Are they bad people? Why did they run up debts, purposely to go bankrupt?
It's a good question, and I get that question, and I only wish I could show these people who have that question, some of my clients. I mean, you have people coming in, they've been unemployed. I mean, today, it's not, unfortunately, it's not unusual to be unemployed for a long period of time. I mean, you have people unemployed for a year, 2 years, longer. They can't get a job in this economy. They're not at fault. You have people coming in, they've been in car accidents, they've had medical issues, cancer, other things that affect their ability to work. Sometimes it's a mental health issue, but whatever it is, it prevents them from working and earning a living. So really, this is their last chance. If you can't file bankruptcy for them, they're going to have to live with the harassment, the phone calls, the letters. And what this does is this helps relieve them of that debt so that they can become a functioning person in our society. And that's what it's about.
Got another question, which is, if I file for bankruptcy, will I lose everything I have? I think we've already touched on that. In other words, let's say you're a mechanic, you have tools, would the court consider that so you can keep in the livelihood that you're supposed to have and you can earn money?
Yes. Actually, there's a specific exemption for tools of the trade. Under New York State exemptions, it's $3,000. Under the federal exemptions, it's $2,175.
Wow.
Plus, you can add on the wild card that we talked about, the other $12,000. If you don't have $12,000 in cash, you can apply it towards the tools of the trade if you have more tools of the trade. And remember, you're talking about like the actual value of the tools. You can buy a tool for, you think it's the greatest tool in the world. Your father gave it to you, or, but if you try to sell it, you wouldn't get that much for it.
Another question here. I'm going to just change the question a little bit. What about a married couple where one of the spouses has, worked and thought they were saving money, thought everything was fine, but the other one is maybe spending money, and they find out that they have massive debts. I know also sometimes at funerals they find out there are massive debts.
I think
what do you do?
You need a matrimonial lawyer first.
Well, what do you do?
That can be an issue.
But what do you do with a married couple like that?
With a married couple, now first of all, if you're a married couple, both parties do not have to file bankruptcy. So if you have one of the spouses, if it's the husband who's in debt, then only he has to file bankruptcy.
Even though they're jointly and severally liable maybe for a debt, or they're worried that they are?
Well, that's what it depends. In other words, if the husband has his own credit card, the wife's not responsible for that credit card.
Right.
It's only the husband. So if the husband's in debt, he can file he can be the one to file bankruptcy.
If anybody wants, first of all, this has been a great discussion. Thank you very much. If anybody wants more information, www.consumer.ftc.gov or www.uscourts.gov, and that would maybe point you in the right direction to get some information. Well, I'd just like to thank you all for being here, and this is a tough topic, and get help and seek the advice of an attorney. Good evening, and justice for all.
Thank you.